Hi, I'm Andrew Simmonds. I'm an angel investor and the managing partner of Simmonds Stewart, a boutique corporate and commercial law firm for technology companies and investors. The purpose of this video is to demystify the legal process for making an angel investment. The process of making an angel investment often takes 3 to 4 months, sometimes longer, and at least half of that time is taken up with documentation and legal process. So, we recommend that early in the process you do a sanity check to make sure that you're comfortable with the entrepreneur, the business and the proposed terms. The legal side of the investment deal happens in 3 key stages: negotiation of a binding term sheet, completion of a binding subscription and shareholders agreement, and satisfaction of conditions precedent and completion. A key point to note is that the Angel Club's lawyer will usually be the one responsible for drafting the documentation, not the entrepreneur. This ensures standardisation of Angel Club investment deals and compliance with NZVIF legal requirements. However, Angel Clubs require the entrepreneur, usually, to pay the investor's legal fees for producing the documentation, which means you shouldn't be out of pocket for that process. This minimises investors' transaction costs, which are typically between 5k to 15k plus GST, depending on the complexity of the investment. The first step in this legal process is the production and negotiation of a term sheet outlining the key terms of the investment in a non-binding document. The shareholders and subscription agreement formalises the term sheet and is a binding document outlining all the terms of the investment. This agreement will include the investment conditions or conditions precedent, which are a set of criteria that must be met prior to the investment being concluded. These typically include capitalisation of outstanding loans, completion and approval of the business plan, and completing company documentation like employment agreements with founders and employee share schemes. Also, IP transfers. The most significant variation between various investments is the type of security to be issued. In New Zealand, there is roughly a 50-50 split between the use of preference shares and ordinary shares in angel deals. The primary difference between ordinary and preference shares is that preference shares rank ahead of the ordinary shares held by founders in a liquidity event. In other words, holders of preference shares have the opportunity to get their money out first in the case of a sale of the company or, worst case scenario, a liquidation. The use of convertible notes is also relatively common in angel deals. A convertible note is a debt holding which is converted to equity upon a specific trigger, such as a follow-on round of financing. Entrepreneurs and investors may choose to use convertible debt over issuing equity because it delays putting a valuation on the company to a later date. Legal fees for bridge note deals are typically less because a shareholders agreement and subscription agreement is not required. As you will know, early stage investing is a high risk investment class, and there are subtleties to each investment deal that can have a big bearing on the success of your investment. However, if you invest through an accredited angel club on the standard NZVIF templates, you will have gone a long way to covering off the risks arising from the legal documentation, leaving you free to concentrate on the commercial, financial and business considerations. Good luck with your investing, and for more information, please see our website and the website of the New Zealand Angel Association.